supplementary list, item number 1.
Good morning, Your Lordship. If you remember, I filed a bail application which I had to withdraw last week on account of the application not having been signed by the accused. It's the same bail application. It's the absolute same application also. The only difference that it's been signed by the accused. If I may just at this conjuncture again, Lordship, becomes a little difficult because the prosecution then, the respondents then had already raised their objections. I was ready with the reply. So anyway, I'll just bring the court up to speed. In any case, Lordship, I filed this bail application primarily on 3 grounds. Firstly, that the grounds of arrest in writing were never communicated to the accused, which is a constitutional statutory mandate. Why do I say that it is a statutory mandate? It's because of section 43B of the UAP Act. Shall I read it again, Your Lordship? It's being quoted in paragraph 9 of the petition as well. It's okay.
Yes.
Right, so I'll just read 43B, procedure of arrest, seizure, etc. Any officer arresting a person under section 43A shall as soon as may be inform him of the grounds for such arrest. We'll stop there. So this statutory mandate and the constitutional mandate under Article 22, from which this was taken out and interpreted from, has been flouted, Your Lordship, inasmuch as the grounds of arrest were never communicated to the accused person. Now the mandate as to whether it is to be communicated in writing was propounded by the Honorable Apex Court in Prabir Purkasta's case.
May please, Your Lordship. Before my learned friend's thoughts, Lordship, I pray this matter may be taken up on Monday, Lordship.
Why?
Lordship, matter was endorsed to the Additional Advocate General, Mr. Andy Shulai, but due to some bereavement, Lordship, in the family, he couldn't come today, Lordship. Some indulgence, Lordship. If notice may be issued today, Lordship,
We've already dealt with this. The only
Lordship, it has been dealt with in the previous matter. We can notice may be issued today, Lordship. We can come prepare on Monday, Lordship.
Fresh notice has to be issued.
Fresh notice has to be.
In any case, you are present now.
Yes, Lordship.
So obviously, the notice is not required formally issued to you.
correct.
The fact that you are present means you are well aware of the matter.
Lordship.
We'll take that as an acceptance of notice.
Of course, Lordship.
But as far as hearing is concerned, if that's the difficulty you face, then Monday then.
Right. We've dealt with this. No problem. Right.
Heard Mr. S.S. Yadav, learned counsel for the petitioner, who has submitted that this is a bail. This is an application for grant of bail under section 483 BNSS on account of the petitioner herein was arrested in connection with Nongpo PS case number 25-3 of 2024, pending before the court of the special judge UA under bracket P capital Nongpo, Riboy district. The fact being that the petitioner, since the day he was arrested in connection with the said case, is on when was he arrested?
Lordship was arrested on the 12th of March 2024.
On 12th March 2024. He is still in custody till date. Next, Mr. H. Karwanang, you are also additional PP?
Yes, Lord.
Additional PP has accepted notice on behalf of the state respondent, on behalf of the respondents. However, accommodation is sought for by the learned additional PP for this matter to be heard on the next day, on the ground that the counsel who is to lead this matter, that is the learned AG, is indisposed on grounds of personal difficulty, on ground of bereavement. No? Accordingly, as prayed for, this is matter for hearing on
Monday क्या date?
18th. Monday city.
Monday is 18th. I'm highly obliged. Good day, Your Honor.
Item number 2.
May it please, Your Lords. My lord, bail application under section 483 of BNSS, my lord. The petitioner's son, my lord, accused, he was in jail, my lord, since 22/4/2024, my lord. And the FIR that has been filed on, my lord, it has been filed, my lord, 25/7/2023, my lord, culminated into filing of an search sheet, my lord. And thereafter, my lord, the trial was begun before the learned session judge, Nongpu, my lord. And in the search sheet, my lord, there are 7 witnesses. Out of 7 witnesses, my lord, 3 has been examined. And all the examined witnesses are vital witnesses. Though, my lord, the bail petition was moved before the learned session judge, Nongpu, my lord, that has been rejected on 2 subsequent dates, my lord. Only on the ground that the release of the accused person may threaten the vital witnesses before the trial, my lord. Your Lordship kindly peruse the, my lord, the rejections ordered by the learned session judge, my lord. Page 47.
No, what is the
The
case about?
section charged, my lord, under section 363, 323, 506, 307 IPC, my lord.
When the offence took place? When did the offence took place?
My lord,
Offence took
it
place.
was, my lord, when FIR, my lord, was alleged on 25/7/2023, my lord. One boy, my lord, minor, was missing from his house, my lord. That was the case, my lord. No name is mentioned in the FIR, my lord. After the search sheet, my lord, the petitioner was arrested and he was tried before the learned session judge. Kindly peruse page 47, my lord. Last portion of the order, my lord. It was dated 27/6/2024. May I read, my lord?
Yes.
Last portion, my lord. The hard learned PP who submitted that the victim in the instant case is in 9
Page
years.
27.
Page 47, my lord.
47.
Last third paragraph, my lord.
Yes, yes.
Hard learned PPs who is submitted that the victim in the instant case is a 9 years old child, and when the TIP was conducted, the victim has identified the accused person. That if the accused person is enlarged on bail, there is every possibility that the accused might threaten the victim and complainant. Further, the learned PP submits that the application for bail of the accused may consider after evidence of the complainant and the victim is recorded, my lord. Now, your lordship peruse the, my lord, the evidences of PW1, PW2 and PW2. PW1 is the victim, PW2 is the informant, and PW3 is one of the vital witnesses. Page 37 onwards, my lord, the evidences. My lord, may I pray, my lord, since the vital witnesses were examined by the learned, by the prosecution, and they were also cross-examined by the prosecution, my lord, and there are only 7 witnesses. Out of them, my lord, 3 has been examined. So, my lord, for the fair trial of the accused person to defend his case, my lord, the accused may be released on bail, my lord, at this stage, my lord.
Yes.
May it please your lordship. Lordship, evidence is going on at present, my lord. And lordship, if I may take your lordship to the statement, the deposition of the victim, my lord, at page 42, who's just 11 years old, lordship. My lordship, prior to that, the relation between the accused person and the victim is that the accused person is married to the maternal aunt of the victim, lordship. So what had transpired on that day is already recorded by the police under 161, my lord. And also, my lord, if I could just take your lordship to page 42 at paragraph 3, lordship. On the following day at around 8 a.m., when I had left home to go to school, the accused person waited for me at one shop. And on seeing me, the accused person told me he will buy me new clothes, mobile phone, and new slippers, and asked me to go with him to Moregaon, Assam. When I refused, the accused person forcefully catch hold of my hand and took me to a sumo vehicle, yellow in color, to his parent house at Moregaon, Assam. I stayed at his house for 2 days. After 2 days of my stay, the accused person told me that he would drop me back to my house using a shortcut leading to Birnihat. However, instead of dropping me back home, he took me to the jungle. On reaching the jungle, the accused person strangulated me from my neck and punched me from my right eye and fled away. I became unconscious, and when I woke up, I was chased by the monkeys, and while running from the place, I met 4 persons in the jungle, and I informed that I was kidnapped by the accused and was brought to the jungle, and the accused person had attempted to kill me by strangulating my neck and had punched on my face on the right side, and I was injured on my face and my nose and my ear was bleeding. Lordship, this is a statement of the victim, who is just 11 years old, Lordship. And further, the accused person knows where the victim resides, as going by the statement on oath, Lordship, and not denied in cross-examination. There was intent on the part of the accused. The intent to kidnap and the intent to harm, maybe fatally, but fortunately it was not fatal, Lordship. So, my Lord, as the trial court had rightly rejected, on the first ground, on the first bail application, Lordship, it was rejected that they may threaten, the accused person may threaten the victim or even the family members. We don't know, my Lord. On the second ground, they went on a medical ground, and the same was rejected, Lordship. Now, my Lord, intent is there, has not been demolished till yet with all the 3 witnesses that have been examined, my Lord, and there is every likelihood that the accused person may approach the child. This is just an 11-year-old child, my Lord. So at this stage, Lordship, we strongly object to any grant of bail to the accused person. No reasons have been made out for granting bail by this Honourable Court, Lordship. And as such, even the bail applications have been correctly rejected by the trial court.
The ground of rejection by the trial court was, my lord, that the vital witnesses, before they giving their evidence, my lord, may be malthreatened. That has been done.
But even that, you have not come against that order.
My lord?
You have not come against that order.
No, my Lord.
That was just annexed and cited.
My lord.
Otherwise, coming against such an order means by
Revision.
by other means.
My lord. But it's a bail
How long
application, my
you
lord.
been in custody?
My lord, for more than 1 year, my lord, 4 months, my lord. About 4 months. 22/4/2024.
When is the next date of the?
Next date, I do not know, my lord.
Lordship, I'll have to seek instructions, Lordship,
In the
because
meantime, my lord,
But you said out of 7 witnesses, 3 have been examined.
yes, my lord.
to my information, my Lord, it appears that out
Also,
of
may
the
page 19, my
7,
lord, search sheet, my lord.
three or 4, Lordship. I'll have to get the correct number, Lordship, as to how many witnesses exactly have been taken up, my Lord. But, my Lord, it won't take long for completion of the trial, Lordship, because evidence is going on full swing.
As far as the merits of the case is concerned,
My lord.
that
It's a bail
that is
application, my
that is
lord.
the
I am not on
domain-
merit, my lord.
That is the domain of the trial court.
My Lord.
My lord.
Eventually, if he is found guilty, he will be convicted. But
I am not on merit on this bail application. So far, bail application is concerned, my lord. I am only concerned that the learned
keeping him in
trial-
custody
My lord.
cannot be. He should not be in the garb of keeping him in custody. That he should be inflicted, a punishment of
Yes,
confinement.
without giving him a fair trial, my lord. That is the, my lord, mandate of law.
But, my Lord, kindly.
I'll impose necessary. He'll see that the usual condition will be there that he'll
My
have,
lord, any
he'll
stringent
have no connection, no contact. with
any
the,
stringent condition. He's a labor, my lord. He's a labor, my lord.
Where is he staying?
He is Morigaon from Assam.
And where is the?
In
Nongpo, my
Ribhoy, my Lord.
Ribhoy. Nongpo, my lord.
Lordship.
He's a labor, my lord.
Labor.
Daily wage labor, my lord. How can he, my lord, influence?
My Lord, it's not about influence, Lordship. Look at how the entire crime was carried out, Lordship.
Maybe.
Any stringent condition, lordship may impose.
Eventually, the trial court will have to, will have to take a, a stand on that
My lord.
as to the evidence, whether they would be sufficient enough to convict him or not. But that is not for this court to.
My Lord, we are not on that, Lordship. Our apprehension is for the minor victim, my Lord.
True. The court will impose condition, and if he violates those condition, then
Automatically, bail can be
bail
rejected.
will be cancelled.
Yes, my lord.
Heard, Mr.
PJ Soy.
PJ here. Direct counsel for the petitioner. Also heard Ms. Anjishila, learned senior GA for the state respondent. Oh, sorry.
Accused name Minmoy Das.
You have also made this informant of.
The informant, the complainant is also a party, Lordship, so notice will have to go,
Then you have
Lordship.
to take notice.
Well, as directed by the registry, I have done it.
Yes, and you have to, because it's
Lordship.
in such a case involves women and children, so
My lord.
perhaps.
My lord.
As per your lordship's judgment, my lord, that's why.
So we'll
Issue notice, Lordship.
before proceeding with the merits of the case, it is noticed that the petitioner has rated the complainant as party respondent herein. Accordingly, on the state respondent number 1 and 2 being present, let notice be. As such, no formal notice is required to be issued upon such respondent. However, that notice be issued upon the respondent number 3, for which the petitioner has to take steps, and the IO is directed to ensure due compliance of service of such notice, and a report to be filed before this court. Today is 14.
Today is the 14th, Lordship.
1 week,
1 week, Lordship.
21.
Maybe on the 22nd, my lord, Friday,
Well, kindly make it 25, my lord.
Lordship.
List this matter for the hearing on 25.
Oblige, lord.
Much obliged, Lordship.
Item number 3.
In this matter, Your Lordship, we have opened up the submission on behalf of the petitioner, and so far the respondent also have concluded the submission, and I'm supposed to reply just on law points, and I have prepared a synopsis, Your Lordship, of the whatever the case is about, and Your Lordship, Your Lordship also had the occasion to reject the condemnation of delay of 105 days in a very similar situation. I have annexed as flag A in my synopsis, Your Lordship. And the chronology of events after the passing of the order by the Honorable Single Judge till the other day, Your Lordship, is also shown in the synopsis, Your Lordship. And I'd like to refer to some judgments, Your Lordship, and just few judgments, and the rest, Your Lordship, may peruse at leisure. I've given the extracts of the judgments, Your Lordship. It is before Your Lordship. The decision number 1 is the judgment of the Honorable Apex Court in the state of Nagaland versus Ratan Singh. And I will come to the judgment number 2, Your Lordship.
What is the citation?
My
Citation,
extracts of
citation?
judgments is already there, Your Lordship. I'm providing the extracts apart from the list book in a page number 1. No, the next.
Have you given the index of the
Yes.
your
Yes. What is your name?
what is the index of your authorities?
It is.
Okay. Oh, this list of books.
These are books, and the extracts also is given, Your Lordship. The entire extract.
Okay.
So far, Ratan Singh is concerned, Your Lordship is aware of the judgment. It is in so far the rules of 1937 that it is up to date, Your Lordship. I come to the judgment in the case of Walam Jingsuk Barem which is item number 2, Your Lordship, criminal miscase number 108 of 2023, where Your Lordship also is had passed this judgment, Your Lordship, along with the Honorable Chief Justice. Then, at para 9, Your Lordship, learned counsel for the respondent. Here, the learned counsel for the respondent, Your Lordship, is Mr. Mozika himself.
Yes.
Contended there is no
Have you
sufficient.
given them a copy of this?
No, this is
Even the
I've given last time actually. I'm giving us again. At para 9, Your Lordship,
Yes.
of this Palam Jingsuk case, Your Lordship, learned counsel for the respondent contended that there is no sufficient cause shown by the petitioner to condone the delay of 114 days. And in terms of section 21 of the Act, which is referred to supra, no application can be entertained beyond the outer limit of 30 days, as prescribed under the Act of 2008. He has further contended that the provisions of Limitation Act 1963, much less section 29 subsection 2, will not be applicable to this case, as the Act of 2008 is a special law governing the proceedings relating to offences falling under the said Act. In this particular decision, Your Lordship, my colleague Mr. Mozika was the counsel for the respondent, Your Lordship. Now, I'll not take the time of the court by reading section 29, which is quoted here. I'll come to the finding of the court. Thus, it was stated that the petitioner, having not shown any sufficient cause for condoning the delay of 114 days in preferring the appeal, has no statutory right to seek for condonation of delay, and hence the application ought to be rejected at a threshold. At para 15 of the judgment, Your Lordship, when the special laws prescribe an outer time limit, this court cannot extend the time on the reasoning that it would amount to legislation by the code itself, which is not permissible, etc., etc., in the absence of which no appeal can be entertained. Your Lordship, I come to the decision of the Apex Court in the case of Consolidated Engineering Enterprise versus Irrigation Department, reported 2008, Volume 7, SSC 169. At para 20, Your Lordship, this is a true extract. Section 29(2) of the Limitation Act inter alia provides that where any special or local law prescribed for any suit, appeal or application a period of limitation different from the period of limitation prescribed in the schedule, the provisions of section 3 shall apply as if such period was the period prescribed in the schedule. And for the purpose of determining any period of limitation prescribed for the purpose of determining any period of limitation prescribed by any suit, appeal or application by any special or local law, the provisions contained in section 2 to 24 shall apply only insofar as and to the extent they are not expressly excluded by such special or local law. When any special statute prescribes certain period of limitation as well as provisions for extension up to a specified time limit on sufficient cause being shown, then the period of limitation prescribed under the special law shall prevail, and to that extent the provisions of the Limitation Act shall stand excluded. As the intention of the legislature in enacting subsection 3 of the section 34 of the Act is that the application for setting aside the award, this is arbitration, Your Lordship, should be made within 3 months, and the period can be further extended on sufficient cause being shown by another period of 30 days, but not thereafter. This court is of the opinion that the provisions of section 5 of the Limitation Act would not be applicable because the applicability of section 5 of the Limitation Act stands excluded because of the provisions of section 29 subsection 2 of the Limitation Act. However, merely because it is held that section 5 of the Limitation Act is not applicable to an application filed under section 34 of the Act for setting aside an award, one need not conclude that provisions of Section 14 of the Limitation Act would also not be applicable to an application submitted under Section 34 of the Act of 1996. Another judgment of the Apex Court, Your Lordship. This is Lingesh, Swaran, etc. versus Thirulangam something, Your Lordship. It's at item number 4. I quote just paragraph 5 of the judgment, Your Lordship. We are in complete agreement with the view taken by the High Court. One, it is found even by the learned trial court that delay has not been properly explained, and even there are no merits in the application for condonation of delay. Thereafter, the matter should rest there, and the condonation of delay application was required to be dismissed. The approach adopted by the learned trial court that even after finding that, in absence of any material evidence, it cannot be said that the delay has been explained and that there are no merits in the application, still to condone the delay would be giving a premium to a person who fails to explain the delay and who is guilty of lashes and delay and lashes. At this stage, the decision of this court in the case of Popat B. Bahiru Govardhane versus Land Acquisition Officer reported in 2013, etc., is required to be referred to. In the said decision, it is observed and held that the law of limitation may harshly affect a particular party, but it has to be applied with all its rigors when the statute so prescribed. The court has no power to extend the period of limitation on equitable grounds. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. At para 5.1 of the same judgment, it was quoted. In the case of Maniben Devraj Shah versus Municipal Corporation of Brihan, Mumbai, 2012, volume 5, SCC 157, in paragraph 14, it is observed and held as under. The law of limitation is founded on public policy. The Limitation Act 1963 has not been enacted with the object of destroying the rights of the parties to ensure that they approach the court for vindication of their rights without unreasonable delay. The idea underlying the concept of limitation is that every remedy should remain alive only till the expiry of the period fixed by the legislature. At the same time, the courts are empowered to condone the delay provided that sufficient cause is shown by the applicant for not availing the remedy within the prescribed period of limitation. Now, Your Lordship, at item number 5, there is another decision of the Guwahati. Para 15, Your Lordship. Having regard to Section 34 of the Arbitration Act 1996, which places the limit on the period of condonation of delay by using the word may entertain the application within a further period of 30 days, but not thereafter. Therefore, if a petition is not filed within the prescribed period of 3 months, the court is left to exercise its discretion to condone the delay only to the extent of 30 days, and that too, if a sufficient cause is shown, which would mean that when a petition is filed beyond a period of 3 months plus 30 days, even if sufficient cause is made out, the delay cannot be condoned. So far the language of Section 34 of Arbitration Act 1996 is concerned, the crucial words, but not thereafter, used in proviso to subsection 3 of Section 34 of the Arbitration Act 1996 would amount to an express exclusion within the meaning of Section 29 subsection 2 of the Limitation Act, and therefore the same would bar the application of Section 5 of the Limitation Act. In fact, the Honorable Apex Court in the case of Union of India versus Popular Construction Company, reported in so-and-so, observed, before us, the appellant has not disputed the position that if the Limitation Act 1963, and in particular Section 5, did not apply to Section 34 of the 1996 Act, then its objection to the award was time-barred and the appeal would have to be dismissed. The submission, however, is that Section 29 subsection 2 of the Limitation Act makes the provision of Section 5 of the Limitation Act applicable to special laws like the 1996 Act. Since the 1996 Act itself did not expressly exclude its applicability, and that there was sufficient cause for delay in filing the application under Section 34. Counsel for the respondent, on the other hand, has submitted that language of Section 34 plainly read, expressly excluded the operation of Section 5 of the Limitation Act, and that there was as such no scope for assessing the sufficiency of the cause for the delay beyond the prescribed period in the proviso to Section 34. At Serial 6, Your Lordship, this extract is from Ramlal versus Reva Coalfield Limited, reported in AIR 1962, Supreme Court 361. In construing
Mr.
section...
Kanta, you have cited this, you have listed down these authorities.
Your Lordship, I'll not take
The court will go through it.
I'll not take the time of the court, Your Lordship. So my submission is that the order of the learned appellate court has to be set aside and quashed, Your Lordship. That's my comment submission.
Lordship, I think we'll be filing a synopsis also, Lordship. The Lordship may then peruse our synopsis.
Fine, do it. You have filed yours.
I have concluded, Your Lordship.
No, you have filed your synopsis.
In fact, my colleague...
Your synopsis of argument has been filed.
It is whatever I have submitted, Your Lordship. I have just put it in a short form, Your Lordship.
Where? In this?
Yes, Your Lordship.
Here.
Yes, Your Lordship.
Mr. B.G.K. Kanta, Senior Counsel, appearing for the petitioner, has concluded his argument and has also filed synopsis of his submission in written form. So, file brief synopsis of his argument in written form. Next, Mr. M.L. Lupir, the counsel for the state respondent, has sought for time to file the synopsis of the argument of the learned senior counsel on behalf of the respondent. How long?
Week's time.
Accordingly, as prayed for, this is matter after 1 week.
In fact, on the other day when the matter was heard, Your Lordship, senior counsel was saying that he will not file anything.
Because they had made these judgments, Your Lordship, today. So
Yeah, they have to respond to your
Lordship.
Your Lordship, in fact, it take 2 weeks more, or 1 week.
Lordship,
1 week.
if your Lordship
Much
can reserve also for judgment, in the meanwhile, I'll file the notes.
No, that will not do. More often than not, this court will not do that.
Lordship,
Once you reserve judgment, then if you tend to delay filing, then it becomes
Lordship.
problem.
We'll file in 1 week's time.
And sooner or later, it has to be released, reheard again.
Lordship.
Might as well finish with the formalities,
Lordship.
and the judgment will be reserved.
Much obliged.
Hello, Lordship.
Daily list item number 1.
Yes, miss.
Lordship, may it please your Lordship, we are submitting a status report, Lordship, and many questions have come before I make my submission, Lordship. In the sense, like, we have also attached the birth certificate, then also the statements of the mother, the father, and also after the interim anticipatory bail was granted by this Honourable Court, the accused person has visited the PS Lordship. Lordship, prior to that, my Lord, if I may just take your Lordship to the status report, Lordship.
Yes.
At paragraph 2, Lordship, this has been forwarded by the concerned IO, Lordship.
Yes, yes.
That the brief fact of the case is that on 10 June 2025, a written complaint was received at Ranikor PS from Samuel Marak, headman of Lower Rajapara, Southwest Khasi Hills District, alleging that Sri Aribul Areng, son of so-and-so and so-and-so, is a Bangladeshi national. It is also alleged that the locality of Lower Rajapara, Southwest Khasi Hills, Meghalaya, don't have any knowledge of Aribul Areng being a resident of Lower Rajapara village. Accordingly, the OC of Ranikor PS registered the complaint, White so-and-so of Ranikor PS, and endorsed the same. Lordship, that during the inquiry, Sri Samuel Marak, headman of Lower Rajapara, was inquired into when he informed that Rana Ahmed and Griti Areng have been staying at Lower Rajapara village, Southwest Khasi Hills, Meghalaya for the last 20 years, and they only have one daughter who is also residing at the same village. The headman has no knowledge that they also had a son. He came to know of this matter only after a letter was received from the office of the subdivisional officer Ranikor, Southwest Khasi Hills, for verification of character and antecedents of the accused person for purpose of issuing scheduled tribe certificate. For the purpose of inquiry, the father of the accused was asked to appear at Gumagat checkpost under Ranikor PS along with his son. He was also further asked to produce all necessary documents in original proving the place of birth of his son. However, Rana Ahmed appeared alone and informed that his son is presently studying in Assam, and so he could not appear. On inquiry, he informed that his son was born in Shillong under East Khasi Hills. Further, Sri Rana Ahmed did not produce any original documents proving that the place of birth of his son. He provided the birth certificate of his son in soft copy. Lordship, this statement given by the father of the accused person was taken under 161, my lord, and we have annexed the same, my lord, under 180 BNSS, Lordship, and we have annexed the same at Annexure 5, page 8, my lord, of the status report. My lord, if I may read, Lordship, that I am to state that I got married to so-and-so in the year 2002, and with her I have two children, so-and-so and so-and-so. Both were born in Shillong. Lordship, this is very, very vital, my lord, this statement. Both were born in Shillong, Barapathar, Jhalupara, near Gada Basti. My lord, if I could just take your lordship, I'll be coming back to the statement of 180 BNSS, Lordship. My lord, if I may just take your lordship to the birth certificate at Annexure 2, Lordship, page 5.
Yes.
Lordship, under 180, the father of the accused said that the accused person was born in Shillong. Lordship, the birth certificate, address of parents at the time of birth of the child, my lord, and where he was born, Lordship, Rajapara, Lower Rajapara, Southwest Khasi Hills, Lordship. Now, this was this birth certificate was issued by an order passed by the District Council, Lordship, at page 6, Annexure 3. Lordship.
Yes.
My lord, this was issued by the District Council in Khasi Hills, Lordship, and this was in Shillong, Lordship. I beg to take your lordship again to section 180, my lord, of page 8, Lordship. If I just may read further, my lord. On being asked why the birth certificate of Aribul Areng was being issued from Ranikor CHC and not from Shillong, because they had travelled all the way to get an order from Shillong, Lordship. So this question was posed to them. I am to state that as I live in Lower Rajapara village, Southwest Khasi Hills, it was convenient for me to issue the birth certificate from Ranikor CHC rather than from Shillong, Lordship. On being asked how is that my father's name is Clearson Marak and my name is Ahmed, I am to state that he is not my biological father. He is like my guardian. He adopted me when I got married to Srimati Griti Areng. On being asked, did I intentionally write the wrong address, Balat, East Khasi Hills, in the form of District Council Code so that I could avoid verification from the concerned PS? I am to state that I did not write the address in the form. It must be a mistake from the office side. Lordship, the form is always filled up by the applicant, Lordship. And on being asked if the accused can understand and speak Garo language, I am to state that my son, the accused person, can understand Garo, but he cannot speak. Lordship, similarly, my lord, the statement of the mother of the accused person was taken up under section 180, Lordship. It's at page 9, my lord. And more or less, Lordship, it is the same response, Lordship. So over here, Lordship, they have submitted certain documents before the concerned IO, and he has appeared before the PS, my lord. Nevertheless, my lord, certain other questions have been raised with regard to the status of the accused person as to whether he is an Indian citizen or not, Lordship. So,
that would be a matter of trial.
my lord, matter of trial. So, my lord, at this
Investigation is still going on.
it's ongoing, Lordship. So, my lord, the accused person has come before this honorable court by way of an anticipatory bail application, Lordship. Now, the investigation has prior to this anticipatory bail granted by this honorable court, they tried to serve him a notice under section 35, but he was nowhere to be found because his parents also did not disclose his exact location. But now, since he has appeared before the IO, my lord, so my lord, I pray that if he cooperates with the investigation, Lordship, this application actually can be disposed of, my lord.
You will. He should. And in any case, you said after the interim order passed.
Only after the interim order was
he
passed.
has appeared.
He's appeared, Lordship.
He along with his father appeared. And his statement also been recorded. I don't think whether it is sent or not, I don't know. But his statement also recorded under section 160.
Okay. When did he appear?
111.
On
11th of
when was the order passed? Last order? 6.
yes.
Lordship.
Heard Miss Jishila, Senior G, for the respondent who has submitted that. Pursuant to the order dated 6/8/2025 passed by this court, in this case, the status report has been filed by the IO. The learned Senior GA has led this court through the contents of the status report, which contains, among others, the statement made by the father of the petitioner as well as the mother of the petitioner under section 180 PDSS. The learned Senior GA has submitted that on perusal of such statement, it can be seen that there is no certainty as to the identity of the petitioner, inasmuch as there are inconsistency as far as the issue of how the birth certificate of the petitioner was obtained, and also the fact that the complainant has no knowledge of his identity as the son of Shri Rana Ahmed and Srimati Griti Areng. The learned GA has, however, fairly submitted that these are matter of evidence which would be looked into by a trial court in due course. Suffice it to say that on this court having allowed the petitioner to go on interim bail, but the said order dated 2025, the petitioner has appeared before the IO on 11/8/2025 and his statement was recorded by the IO. In fact, even before the application, even before this instant application is made before this court, the IO, has he issued that notice under section 35, or he had
No, my lord, not issued.
contemplated?
They tried, my lord, but they could not.
The IO has contemplated issuance of a notice under section 35. 35(3), nay?
Yes.
Is it 35(3)?
My lord,
Is it 35(3)?
under section 35 BNSS, lordship.
35, which
Subsection.
My lord. The status report simply says 35, lordship. So whether it will be 3 or not, lordship.
okay, we'll keep it at 35, but 3 would means that if he is not required to be arrested, then
My lord, but
he is to be questioned.
but since it's not given, my lord. So
But the same could not be affected. Be that as it may, the learned senior GA has not made any strong objection to the prayer made in his petition, but has submitted that if enlarged on anticipatory bail, stringent condition may be imposed on the petitioner. Mr. I. Chaudhary, learned counsel for the petitioner, on the other hand, has submitted that if enlarged on anticipatory bail, the petitioner would bind himself by any condition to be imposed by this court. On the basis of the submission made by the legal counsel for the parties, without going to the merits of the case of the petitioner, this court is also inclined to allow the prayer made in this petition, and accordingly, in the event of his arrest, the petitioner is directed to be released on bail on a condition that all those usual conditions,
my lord.
he shall not abscond, and we'll fix the bail bond at 20,000 with one surety of like that he shall present himself before the IOS and when required.
Much obliged, lordship.
Item number 2.
Wait, please, Your Lordship. Your Lordship, we're filing the affidavit in the course of the day. I've served copy to my friend already.
So you have to file the status report.
Your Lordship, with regard to the inquiry, we have the inquiry is still going on, Your Lordship, so we have not received the status report. But the affidavit in opposition that we're filing, we're bringing on record the award that has been passed, Your Lordship, because their claim is that there was no award.
Lordship will go
But
through.
in the meantime, since you've been directed to file the status report,
Yes, Your Lordship.
you should do so.
Yes, Your Lordship.
At
We've,
whatever stage it is.
yes, Your Lordship. We've conveyed to the concerned officer also, Your Lordship, to take it up on a priority basis and to forward the status report immediately, Your Lordship.
Because once the status report is filed, perhaps we would know whether it's required for this matter to proceed further or to be concluded at
Yes,
certain
Your
point.
Lordship.
Instead of going through the whole process of
Your Lordship.
letting the pleadings be completed and finally to be heard on merit and so on and
Yes,
so
Your
forth.
Lordship. Your Lordship, with regard to the status report, I'll seek 2 weeks' time, Your Lordship. I'll make sure that by the next date it would be produced before this honorable court.
Please.
Lordship, with regards to the rejoined affidavit, Lordship, we will go through the affidavit and file.
Have you received a copy?
I've served it already, Your Lordship.
Okay. But you
I
have
just
not.
served it this morning, Your Lordship.
Okay. Yes, that the Honorary Learned GA has submitted that the affidavit in opposition on behalf of the respondents have been filed. And will be filed in course of the day. As to the direction of this court for filing of the status report, the learned GA has submitted that the same has not been received from the officer concerned and has made a prayer that this court be pleased to allow filing of such status report on the next date fix. Mr. Learned Counsel for the petitioner has submitted that as and when the affidavit in opposition is filed, the petitioner will be allowed some time to file a rejoinder to the same if so required. Accordingly, as prayed for by the parties, this is matter to 2 weeks.
Obliged, Your Lordship.
Item number 3. May it please Your Lordship, I'm praying for some accommodation on behalf of Mr. J. Shilla. Lordship, he has some personal difficulty today. No objections.
Ms. Learned Counsel for the petitioner has sought for accommodation on the ground that the Learned Conducting Counsel, Mr. J. Shilla, is indisposed. The prayer not be objected to by Ms. Learned J. Appearing for the respondent, matter is adjourned. This is after 2 weeks.
Much obliged.
Give me a pine up to